Just to let everyone know, we're waiting on the legal officer. There's a bit of a matter that's arisen, so are we happy to start in 10 minutes' time? Cool, lovely, thank you.
Hello. I don't know if you can hear me.
Righty, good morning everyone. Thank you very much for waiting and for your patience, and welcome to this morning's licensing subcommittee meeting. Before we begin, I just want to make you aware of the fire instructions, so you know the procedure to follow if we need to evacuate. There are no further fire drills planned for today, so if you do hear the alarm, please evacuate the building using the stairs outside the council chamber entrance, and then follow the green signs towards the fire assembly point in Knoll Road car park. Please do not use the lift. Do not re-enter the building until you've been told it is safe to do so. And if you have any mobility issues regarding not being able to use the stairs, then please let myself or my colleague Jenny Merton know, and we will advise on the best course of action. So on that point, item 1 on the agenda is the election of a chair. Please can I have a nomination for the position of chair? Thank you, Councillor Gordon.
No, that's mine. Sorry. You're that side. Can I nominate Valerie White, please?
Thank you very much. Do I have a second?
Yeah, happy to second that.
Thank you. Are there any other nominations? Nope. All those in favour of Councillor White assuming the role, please indicate. Thank you very much. I therefore confirm that Councillor White is duly elected as chair for this hearing. I now pass control of the meeting to Councillor White.
Thank you. And once again, apologies. Let's get down to the business. Before we begin, I will ask my colleagues to introduce themselves.
I'm Bob Rakes, I'm councillor for Heatherside Ward.
Mark Gordon, councillor for Bagshot. And I'm Councillor Valerie White, also councillor for Bagshot and also chair of the licensing committee here at Surrey Heath Borough Council. Right, can I ask any other officers, please, to introduce themselves?
Good morning, everyone. I'm Paula Barnshaw, Senior Licensing Officer.
Good morning, everyone. Gavin McIntosh, Senior Environmental Health Officer.
Good morning, everyone. I'm James Hall, Democratic Services. I'll be clerking the meeting.
And on screen we have Rebecca Batten, who is... Sorry, Rebecca, I did it for you.
Thank you. I'm a solicitor in-house for Surrey Heath Council.
Thank you. Okay, item 2 on the agenda is declarations of interest. Would any members of the subcommittee please confirm that they have no disclosable pecuniary or affected interest in the application before us this morning? Members? Councillor Gordon.
Declaration of interest. I manage a bar that shares a lot of clientele with the nightclub and does feed them, just as a point of interest.
Thank you.
I can confirm that I have no disclosable pecuniary interest or non-pecuniary interest in the matter.
And that goes for me as well. Okay, item 3. Purpose of this item is to determine an application to vary the premises licence of Trilogy, 52 High Street, Camberley, GU 193RS. And before we start, I'd like to check that all those present have received copies of the papers. Yep. And I would like to draw your attention to item 3 on the agenda, where you will find set out the procedure that will be followed during the hearing. Do you all understand the order of business which we will follow? Everybody's content? Thank you. Item 4, determination of the application for the variation of premises licence SHBC PR 00599, Trilogy, 52 High Street, Camberley. If we're all ready, I'll call upon Paula Barnshaw, the Council's licensing officer, to present the summary of her report. Paula.
Thank you, Madam Chair, and good morning, ladies and gentlemen. This variation application has been made on behalf of Epic Bars Camberley Limited, and the application relates to the premises licence at the nightclub in the High Street, formerly known as True, now will be called Trilogy. The premises licence permits performance of dance, exhibition of films, live and recorded music, late night refreshment and the retail sale of alcohol. The terminal hour for the nightclub is the latest issued in the borough, and the licensable activities cease Friday and Saturday at 4 a.m. and the rest of the week at 3 a.m. The opening hours extend for a further half an hour to allow customers to retrieve belongings, finish their drinks and disperse the premises. The variation application has been the subject of formal representations from 2 responsible authorities, and it therefore falls to this licensing subcommittee to consider and determine the variation application. In section 1, I have listed the changes to the operating schedule and the new layout of the premises. The application itself can be seen at Annex A, and the plan of the premises can be found at Annex B, and I apologise, the blue lines and the red lines mentioned are very faint. Please note the permitted licensable activities and the terminal and opening hours of the premises remain the same, they're not changing. In section 2, I've listed the details of the 2 representations from responsible authorities, and the full representations can be read at Annex D. The fire service representation is on page 39. It doesn't seem to have Annex D at the top of the page. I confirm these were received within the consultation period. The changes to the internal layout of the premises, detailed as Room 1, Main Room, and Room 2, Party Room, have not invited representation. The representations from responsible authorities concern the removal of conditions, and for clarity, I have added at Annex C the current premises licence and highlighted in yellow the conditions the application seeks to remove, and typed in red the proposed conditions. Regarding the new, and the other representation is regarding the new proposed bar 4 on the 2nd floor, with proposed serving hatch opening directly onto the external smoking area, and proposals to permit customers to purchase and drink alcohol outside on the smoking terrace. On page 39 is where you can find Surrey Fire and Rescue's objection, and that's based on the licensing objective public safety, and is in regard to the capacity of the premises. I understand that this representation may be withdrawn following a satisfactory fire risk assessment report, but I still haven't had confirmation from Mr. Clark regarding that. The environmental health objection refers to public nuisance licensing objective, can be found on page 41 and 42. By increasing the number of customers in the smoking area and permitting those customers to purchase and consume drinks will negatively impact residential properties. The Licensing Act encourages mediation between parties, and both responsible authorities have discussed the application with the applicant. However, mediation has been unsuccessful, and therefore the objections have not been withdrawn, as far as I know. Annex E, please see photographs of the outside of the premises, the stairwells and internal areas and smoking area. I thought that just might provide a bit more information for you. Annex F, I have included a plan, and this shows domestic rated properties denoted by green, orange and purple coloured dots, depending on the council tax bound in the surrounding area. Section 3, I've listed the policy and statutory considerations that the committee must have regard when considering and deciding this application. And in section 4 of the report, I've copied sections taken from the council's statement of licensing policy, although as always, the whole council's policy must be considered when considering and deciding this variation application. In section 5, I've included excerpts taken from the Home Secretary section 182 guidance pertinent to the variation application. And in section 6, I've detailed the steps the committee may take to make a decision that, and the appropriate measures it can take. May I emphasise that members must give reasons for their decisions. In section 7, members' attention is drawn to the legal implications of this application and hearing, and details the rights of appeal for the applicant and objectors if they feel the decision is unjust. I've also detailed that there is a right to call for a review of the premises licence if in future problems occur. In Section 8, confirmation that the application was correctly advertised for the full 28-day public consultation period. Finally, members are asked to determine the variation application for Trilogy nightclub situated at 52 High Street, Camberley, and provide reasons for any decisions they make. Thank you.
Thank you, Paula. The panel will now hear the representations from responsible authorities and any other parties. Please note that your written representations have been circulated to all parties to the hearing and have been read carefully by the panel. Would those addressing the committee clearly state their full name and who they represent when making their representations? And we have no timing restrictions in force for this committee, nor does it restrict the number of speakers from whom it expects to hear. However, please consider carefully whether you can add anything further to what may have already been said. Interested parties are reminded that the committee will not attach weight to the volume of the oral submissions. The committee is only able to consider the variation in relation to the 4 licensing objectives, which are prevention of crime and disorder, public safety, prevention of public nuisance, and the protection of children from harm. I now call upon the clerk to confirm who the speakers are for today.
Thank you, Chair. In terms of responsible parties, Gavin McIntosh from Surrey Heath Borough Council will be speaking as the environmental health representative. We also have representatives of the current licence holders Trilogy speaking today.
Thank you. Are there any questions from the committee at this stage? No? Okay. Right, I call upon environmental health representatives, to present the environmental health case for the objecting to the application to vary the premises licence.
Sorry, Councillor, before Gavin speaks, number 5, so I'm not interrupting, relates to the applicant questioning the licensing authority. It's actually an important point, because my understanding from an email was that Dan at the fire authority has withdrawn his objection.
Sorry, there was an exchange between Mr. Elias and Dan. It must have happened over the weekend. I just read some emails this morning, and it seems that Dan, the fire service person, doesn't seem to agree with the fire risk assessment. So,
But he withdrew his objection last week. I have an email which I haven't printed out because I thought he's withdrawn his objection.
yeah, he didn't actually. Sorry, he didn't communicate that to me. I haven't received that email.
So I wish I'd known that in the 30 minutes because I could have
Sorry.
got a copy of that. I mean, I'm a little uneasy going ahead if the councillors think that there is still an objection from the fire authority. I mean, we can pass on, and when I can open my laptop, I can try and find the email.
And so, is it possible for you to outline the way that you've attended to the objections that were there and the guidelines?
My submissions,
Is
Councillor.
that acceptable?
Yeah.
Everybody? Thank you. So did you still want to put a question to the licensing authority, or was that it?
Well, my question was, the fire officer has withdrawn, hasn't he?
Sorry, I haven't had official confirmation from him that he's withdrawn. He said that he would withdraw under certain conditions, but because of the email exchange that seems to have happened at the weekend, it looks like he's not happy with the fire risk assessment. I'll happily go and print out those emails.
I've seen those emails, but last Thursday he withdrew his representation. There is an ongoing discussion about the fire risk assessment, but for the purpose of this hearing, my understanding was he has withdrawn his representation, but you haven't seen that. At some stage, when we have a break, I'll dig that out, councillors, because I think that's important. I'm not sure if I was you, I'd be happy going ahead and thinking the fire officer isn't happy.
May I ask our legal department, is sight of an email to the third party enough for us to accept that the objections have been withdrawn?
I'd like to say that during the deliberation of the actual committee, there would be an opportunity to consider a subject to requirement that these are satisfied, the certificate, the risk representation is satisfied before the decision of the licensing comes into effect.
Okay, perhaps when we...
I mean, if evidence can be produced, then it's up to you whether to admit it.
So what we'll need then is a printout of what Mr Woods received, and also printout of what deliberations you've had over the weekend. Is everybody happy with that? Yeah. Right, is there any questions from the committee? No. Gavin.
Thank you, Chair. Gavin McIntosh, Environmental Health. Environmental Health would like to object to this variation application on the following grounds: prevention of public nuisance. The applicant's proposals relevant to this objection are a new drinks bar within the existing designated smoking area at roof level, which will have the potential operating hours and the current premises licence, removal of the current restrictions applied to the smoking area, notably Condition 13, no alcoholic drinks, Condition 14, no bottles or glasses, Condition 15, limit of 30 persons within the area. The current smoking area is located at roof level, is restricted to 30 people and prohibits drinking within the area. Although the area is well screened with louvered panels, these will only offer very limited noise attenuation. There is no roof to the structure, therefore there's a high probability of noise escape. Even with this high probability of complaints, there are no records of noise complaints from the smoking area as it is. Therefore, it can be inferred that the current restrictions applied to the licence are one of the reasons that the premises maintains the licence objectives of public nuisance. Bearing in mind the closest resident property is located approximately 15 metres from the closest edge of the smoking area, this emphasises that the current restrictions applied to the licence must be working in some ways to protect the residents. The applicant, in removing Condition 13, will allow an increase in the number of patrons that can use the space, which will only increase the noise level. By opening the bar within this area, it will encourage these additional patrons to dwell for extended periods of time and change the overall character of the smoking area to an area where people spend a limited amount of time to smoke to an area where they will now be socialising. Increasing the noise level within more people and changing the character of the smoking area both have the potential to result in an increased probability of noise and nuisance impacting nearby residents. The applicant is also proposing to operate the area until the terminal hour, meaning that the probability of noise and nuisance impacting nearby residents will only increase the later it goes into the morning. Within the original variation application, it should be highlighted that no supporting evidence was provided to demonstrate how the premises were to uphold the relevant licence objective. Initial discussions were had with the applicant, but they were unwilling to continue any discussions and indicated they wanted to proceed to a hearing to make a determination of this application. It is understood that further supporting material has been provided at a later date by the applicant in the form of a new operating manual and some additional acoustic attenuation. Although good practice in controlling patrons via the operating manual and physical acoustic attenuations have the potential to control and reduce noise and nuisance, there is no guarantee of this. The acoustic properties, technical sound reduction indices, calculations of the proposed acoustic attenuations have not been provided, so there's no indication of how successful these would be in controlling noise. So to sum up, Environmental Health of the opinion that removing the capacity limits of the smoking area and providing a bar will potentially change the character of the area, and this is the possibility that will result in increased noise and nuisance to the nearby residential properties, the closest being only 15 metres away from the furthest edge of the smoking area. The likelihood of these impacts increase later this area is open, it's open to 4:30, so there's potential there to cause disturbance. Although some mitigation has been provided by the applicant, there's no technical details determining the success of this mitigation. Environmental Health are therefore of the opinion that the applicant has therefore failed to demonstrate how the licence objectives for the protection of public nuisance will be maintained with the proposed changes. Thank you.
Thank you. Sorry. Does the licence holder have any questions they'd like to put to Environmental Health representative? No? Any questions from the Okay, and I now call upon the licence holder to outline their case.
Thank you, councillors. As Paula has indicated, there are various parts to this variation application, which Paula has very helpfully set out at point 1.3 of the report on page 3. I'm going to deal with those very briefly because some of the parts of the application are not objected to, and other parts of the application are objected to by Gavin. And I only make an obvious point that whatever your decision on the disputed parts, there are still parts that nobody objects to, so hopefully that's okay. The parts that are not objected to are the changes to room 1 and room 2 in terms of alterations to the layout. There's an alteration to a condition requiring photo ID to be scanned into an ID scanner, and the only alteration to that is that the senior manager can authorise somebody to go in without ID if appropriate. So that's, for example, if I turned up and I didn't have ID, the manager, Jerry, could make a note that he's checked me, I don't have ID, but he's happy that I could go in, and nobody objects to the change there. The police are happy with that. Environmental Health, Gavin, don't object to that, and licensing don't object to that. So there are 3 parts to the application, in effect, that Gavin objects to, and each of those parts we would ask you to consider on their own merit as well. The previous operator used this outside terrace on top of the building to allow smokers to go out there. There was a capacity restriction of 30 on that outside area. We are asking, point 1, that capacity goes to 60. The second point is that nobody was allowed to take a drink out there. So if I was in the club and I had a drink with me and I wanted to go and smoke, I couldn't take that drink outside. I had to leave it in the club on a shelf, etc., go out and smoke, and then go back to that drink. And the third point is that we want to put a small bar in that terraced area on the top. I think Jerry said it's about 3 or 4 foot long. It's not a big bar, but we'd like to put that facility in outside to enhance that area outside. So there are 3 different parts to the part that Gavin objects to that you may wish to consider as well. The people with me will be available to answer any questions. Jerry is a very experienced designated premises supervisor. He doesn't want me to tell you how experienced, but he did run this venue at the start of the 2000s, so he knows the venue very well. He was there for about 5 years. And Rebecca is the operational training director of Epic Bars, who make the application. I'll present the application to you, hopefully, as briefly as possible, and both Jerry and Rebecca will be here to answer any questions. In all the additional documentation that was submitted when the hearing was fixed, included in there is a case summary that I've put together. I'm just going to bullet point that. If you've been able to read it, that in essence is the application, but I'd like just to reinforce 1 or 2 points briefly. So as I suspect, as experienced committee members, you will be aware, this venue's been a nightclub for many years, certainly as far as we can recall, maybe 30 or 40 years. The outside area on the top has been operated for the last 15 years, as far as we are aware, and that's been operated by a company that keeps changing its name, but latterly it was called Recom. Before that was Luminar. It was one of the biggest nightclub operators in the country, and it operated that area with a restriction, as Gavin has said, with 30 people, and you couldn't take your drinks out. There has never been a complaint about the use of that area. So even with 30 people out there, and we understand from Recon that it was regularly at capacity, there has never been any noise complaints made by anybody in 15 years about that area being used. So when at the end of the submissions you make a decision based on the evidence before you, uncontested evidence is that this outside area has been used without a single noise complaint to environmental health. At Recom, the site wasn't working. Recom have closed a few sites around the country. They were going to close the sites. My clients, Epic Bars, took the sites off Recom. They have invested in the region of £250,000 in this site in Camberley. All of the staff who were going to be made redundant have been kept on by my clients, and they've invested to make the premises better, safer, and taken on more staff as well when they've opened over the weekend. We've just had a weekend, our first weekend of trading. You'll know where the premises are in terms of the shopping centre. Epic Bars is privately owned. There's no bank loan or money from investors going in. The money that's been invested in this site has been money that's been made in other nightclubs and is rolled over into investing in the premises, and they've operated in over 40 towns in the United Kingdom and are one of the leading operators in the country. They understand how to operate controlled premises, prevent crime and disorder, and control noise. Submitted to you is a detailed operational manual that Rebecca is primarily responsible for. You have the general Epic operational manual, but it is fair to say that as they spend more time in Camberley, there'll be different points added or taken away, and the operational manual will evolve depending on what happens at the site, and certainly we've already been open a weekend. And as you know from the objection, and it's probably important from an evidential point of view and a legal point of view in your decision, the objection is based on potential for increase in noise rather than any evidence as such that this area has caused problems or will cause problems. And there are a number of reasons why Epic would like to make this application and change the outside area. The first is that in our experience, and I'm going to go as far as to say in the industry experience, customers, females in particular, leaving drinks unattended and going into outside areas is simply not acceptable. There is a risk to customers to do that. There's a risk to females because you have to go upstairs to get to this outside area, so it's not as if you could leave it there and watch your drink as you're standing outside. It is something that Epic Bars, and I would suggest the majority of the late night industry, would be against. It doesn't promote the licensing objectives. It raises issues of safety to our customers, and that's why the first part of the application is to allow customers to take their drinks outside with them. The second part, to increase the capacity. The overall capacity of the nightclub is mid-700s. 30 people smoking, it is not sufficient. We understand from discussions with Recom that there were issues in terms of numbers of people wanting to go out to smoke, and having traded the premises for one weekend, Jerry told me that he's had issues on the stairs going to this outside area because more than 30 people want to go out and smoke. And again, that has potential issues for safety of people who are queuing on the stairs. Years ago, you will know this, I didn't, there used to be a smoking area at the front of the building which caused problems for the operator. So Luminar Recom moved it upstairs, which is a far better place for it to be, but logistically clients have to go up the stairs, and simply we don't think 30 is enough. We think that it may cause issues, and certainly Jerry was telling me, and he'll tell you if you want to ask, that he had difficulty managing queues, having to put extra staff to manage queues and clicker people in and out of the smoking area. So that's, again, from a public safety and from a customer point of view. And the third point, we'd like to put a small bar out there. We'd like the area to be more than a smoking area. I've been told by Rebecca it's not a smoking area, it's an outside area that we would like to use. They would like to have a small bar out there. We don't envisage, certainly in this climate, that it's going to be excessively used. But if customers want to be outside, if they want to have fresh air, then we would like them to have the facility to buy a drink from this bar. And that will enhance the offer to the customers. That's why we want to do it. So there are three parts to changing the use of the outside area that we would like to change, and we'd ask you to consider each three on their own merits. We'd like customers to take drinks outside. We don't like customers leaving drinks unattended. The capacity, we say, is not sufficient. Recon would say that, and we say that after 3 nights of trading over the weekend. And lastly, as part of investing and enhancing in the building, we'd like to have the small bar outside. In terms of the weekend's experience, we did find it difficult with just 30 people being allowed outside. We don't see that the use of the area will dramatically change. It will predominantly be an outside area used for smoking. We don't see that having a small bar out there will enhance it to such an extent that it changes. You've seen rather unflattering photographs of the outside area. It won't look like that when it's absolutely completed. It will look a lot better. At the moment, it looks like my grandma's backyard, and it's not particularly. It doesn't look particularly good, but there will be improvements to that, which are being made as we speak. In terms of noise mitigation measures that we are putting in place, and this is dealt with at paragraphs 14 to 23 of my case summary, we are putting materials on the fencing around the area, the outside area. We have to comply with the smoking requirements, so we can't enclose it. Gavin's quite right. There's no roof on it. We can't put a roof on it, or else people wouldn't be able to smoke out there. But we are able to put various materials that we've used elsewhere around the side of the smoking area, which will assist with dealing with any noise in that particular area. Operationally, you have seen the operational manual. I don't expect that it's all been read, but sections 16, 17, 20, there are sections on dealing with outside areas, managing noise, managing smoking, and this will be enhanced by Rebecca as our experience of the Camberley site moves on. But there are detailed measures in there which will be implemented at the premises. In particular, there will always be a member of door staff in the outside area. There will be a member of staff in the outside area. Gavin has raised concerns, so we are aware of those concerns about potential for noise. So staff will be managing patrons and asking them to keep the noise down and working with the patrons to ensure that there isn't noise from that area, as well as the physical measures that EPIC are taking. The nearest flat to the outside area, which is on environmental health submission, is our flat. We're not sure about any residents in one or two of the other flats that have been highlighted, but we will work, if there are issues, and we don't expect that there will be, we will of course work with environmental health, and we can make a manager's telephone number available for anybody who has concerns about this area. EPIC are experienced in managing and looking after outside areas, and evidentially I'd ask you to note, and no need to turn there now, but Rebecca has given us details about outside areas we have in other clubs, in Bangor, in Cheltenham, in Maidstone, in Hereford, where outside areas almost abut residential properties, and we don't have issues in these premises. And I've given at paragraphs 17, 18, 19 and 20 those sites, some capacities. The High Wycombe outside area has a capacity of 120. Cheltenham operates with 75. So we are experienced in operating these outside areas and operating without issues of public nuisance being caused. The last thing, although Gavin is sitting here and making his submissions and we are sitting here and making our submissions, somewhere in the middle we all agree we don't want any noise to be caused to the residents, because if we spend £250,000 on this site, and if you allow all or part of this application, and if there are then issues, our licence and our investment will be at risk. So it's not something that we don't make this application just because we think it's a great idea. We make it having thought about potential issues with regard to the use of this area as well. So that, I think, in summary, are the main points of the application. That the site, you will know how long the club's been there, the outside area has been there without any noise, and yes, we are looking to put some extra people in, but as far as our understanding from Recom and the weekend is concerned, you know, the weekend, that outside area, we didn't allow more than 30 people in, even though they wanted to go in, and those people do not cause a noise nuisance. And we say that the changes that we ask you to allow will not increase any noise nuisance, because there simply isn't any. And of course, the final points, and I'll just very briefly deal with a couple of bits of law in closing. The final point is you will know that if there is an issue, Gavin will be onto us straight away, and if an issue isn't resolved, then we'll be back here facing a licence review, and the whole licence is under threat, which of course, having just spent all the money and moved into Camberley, is the last thing that we want. But we say that the noise mitigation measures through the Opt manual, through the evidence of the other sites, and the management that Jerry and the team will bring to the site will ensure that there will be no public nuisance and that licensing objectives are promoted. We spent, just a final point, in about £6,000 to £7,000 in addition to, in respect of this outside area to do with coating the fencing, etc., etc. We can't, as Councillor Gordon will know, we can't enclose it fully, because otherwise we can't allow people to smoke out there. So those who understand the technical side of it much better than me, there is equipment you can put on the fences that assists in terms of controlling the noise within that area, and that's all being done as well. So those councillors, that is the application. Rebecca, Jerry and myself are here for questions with regard to it.
Okay, I have a couple of questions, and I have to say, in this day and age when we're discouraging youngsters from smoking, that it's a strange application to come to us. But anyway, forgive my naivety, I haven't been to a club for years and years, but wouldn't it be a good idea for them to finish their drink and then go upstairs and have a smoke or a vape, whatever they do? And if you're allowing a bar up there with glasses and everything, why can't they take the drinks that they've already got with them up to the area instead of having to open a bar?
I think the answer to, so why can't they take the drinks up there? Because they're not allowed to at the moment. So that's one part of this application. There is a condition that you cannot take a drink to the outside area. So that, if I understood the question right, that's why they don't take them.
So that could be a variation then, that they take their drinks with them instead of having a bar opened up there.
So it would be open to you. which is why I said there are 3 parts to the outside area application. It would, of course, be open to you to allow the variation to allow customers to trade drinks outside, but not to allow the new bar. That's a matter for you. We've asked for 3 things: capacity, new bar, taking your drinks out. I would ask that you decide those 3 individually, collectively, and if you're against us on one of them but are happy with the other, please don't refuse us on all 3 if there's 1 or 2 that you're happy with.
But going back to finishing the drink, surely you'd finish a drink before you went outside to have a smoke.
Yes, Jerry, why don't customers do that?
Because, I mean, regulating their behaviour is easier said than done, I have to say. They like to take their drinks with them. It's just something they like to do. In an ideal world, we could have them all leaving their drinks in one place before they ascended the stairs and went up, but that's just not the way that people think, unfortunately. Which is why we've made the application for the outside bar and why we've made the application for them to take the drinks out there. It's just a matter of you cannot mitigate everyone's behaviour.
No, I just thought I'd ask the question.
Yeah,
That was all.
but I think in an ideal world, your question seems to make sense, but we can't control what customers want to do. And as Jerry said, holding the drinks is something that they want to do whilst they're having a cigarette or, yeah.
Any questions from Mark?
On the subject of drinks outside, on the pictures so far of the current situation, there are no sort of areas to hold drinks. I know obviously the reason why, because they can't take drinks currently. Are there plans to put shelves in or poster tables or things so if you can take drinks outside, you can put them somewhere?
Yes, so the plan is, if we are obviously allowed drinks out there, we have poser tables that would go on the edges, so there's safe areas for them to pop their drinks down. There's also, will be a bin out there so they can disperse of any bottles and empty cups. And we have our floor walkers. They rotate every 15 minutes around the whole venue, so they are there also to clear away any empty cups that people may pop on the floor. In terms of our glassware, all of our glassware is polycarb. It would just be the bottles of beer or VK that people have. Our main seller is Spirit and Mixer, and again, all of that is in polycarb plastic cups as well.
Any other? Bob?
Just a quick question. The noise mitigation, I think Gavin mentioned that there'd been no data supplied. You've said, oh, we're fixing that. But I like numbers. You haven't provided any technical information on what the absorption of the sound would be or any other data. Why is that?
No, that is a good question.
I can answer. Sorry, we have been installing it last weekend. The noise mitigation expert is then coming out this week to assess the work that was done by our contractors. So at the moment, we physically couldn't provide anything before when we submitted this.
So was the noise level measured this weekend while it was being used?
Yes, I mean, I asked Rebecca and Jerry this, that there were checks taken by physically walking around outside and listening, and you could not hear the outside area outside when you were outside of the building.
But no measurements were made of the...
Couldn't hear it, so the measurement would be nothing. That's our evidence. It's a little bit that's a little bit more than conjecture, because I asked them to take those checks and you couldn't hear anything. Is that right? Yes.
Okay.
Coming back on that point, in terms of where the measurements can be made, because ultimately if you're doing walks around to find where the noise is coming from, it all depends where you're standing, because ultimately where the actual smoking area is, there's no accessible area. I would suggest that you could take a reading from that wouldn't be next door. It needs to be from the street levels, which is quite a long way away, which is shielded by buildings. So theoretically that wouldn't actually provide any indication of if there was noise complaints available. Another point I would like to say is that when I say 15 metres away from the edge of the smoking area itself, we know that the flat, the joining next door, belongs to the flat. So we're actually talking the one that's next door to that, which is the 15 metres we're talking about there. So in terms of also potential, 'cause I remember Mr. Woods said about the evidence I was given was potential. Well, what I will say on that, in terms of noise, if you're doubling the capacity, that will increase the noise level. Physics will say that when it comes down to it, so it will increase noise level. So that evidence is actually factual.
Do you want to come back on that or not? Right, any further matters that Paula or anybody else would like to bring up?
Just to mention, you mentioned about drinks being left unattended. So we have no recorded complaints or records that of drink spiking incidents in True, or now called Trilogy, for the last year and a half. So I appreciate it's been closed since January, but yeah, we have no records of drink spiking incidents.
I think we're aware of a considerable number of issues in many premises around the country with regards to it, which is why we don't like it.
Right, at this point in the proceedings, I will ask the licence holder and the interested parties who wish to sum up their cases, and I would ask that you do not introduce any new information or evidence at this stage. So, the floor is yours.
I think that ultimately from my representation, there is no evidence been provided that demonstrates that by opening the bar and operating with an increased capacity at the smoking level, at the smoking area, there is no evidence to suggest that the prevention of public nuisance will actually be maintained in the applicant actually doing that. So yes.
Now the floor is yours.
I didn't mean to be rude by that, but the applicants generally get the last word.
I mean, in some ways, from a Licensing Act 2003 point of view, this is an interesting case. It's important to us and obviously important to Gavin, because Gavin's standpoint would be on any application, if you make an application for anything, you need to provide evidence to completely satisfy the councillors and the committee on what you're applying for. Now, that's not what the Licensing Act is about. The Licensing Act is about light touch bureaucracy and allowing premises to make applications. If there are no objections to applications, then, as you will know from your experience, we wouldn't be here, because applications are granted without hearings, unlike years ago when we had to come and present applications to committees, even if there weren't any objections, to magistrates to try and get granted. So the whole ethos of us being here is because there is an objection to this application. And there are two parts that, and your legal advisor is listening and will, I'm sure, advise you on this when you're considering the matter. But the section 182 guidance at 9.43, which is in your report, says any determination you make must be based on evidence. Now, we're not in a court of law, it's not beyond reasonable doubt or anything like that, but there must be evidence. And you have no evidence against any part of this application. You have a representation which refers to potential. We have an oral submission which talks about, it started at high probability with 30 people, and higher probability is becoming a higher probability if we change it. But all of that is speculation, unfounded, if I'm being extremely cruel, on anything. And this isn't a club which is opening now and we're saying it'll be fine, don't worry about it. This is a club that's had 15 years of using an outside area without a single noise complaint being made against those premises. And the leading licensing High Court case, which I'm not going to bang on about, of Thwaites, which your legal officer will be aware of, was all about that, where the objections were to later hours. Well, if you have later hours, there'll be more crime and disorder and there'll be more trouble, etc., etc. And the High Court said, you can't speculate like that. You have to have evidence, which is why the guidance now says you must have evidence to reject an application or determine the position. Our evidence to you is that the outside area is traded without issue at all. There are no residential representations. No resident has seen this application and thought that might cause us a few problems if you do that. We have similar outside areas in many other venues close to residents that do not cause noise nuisance. That's our evidence, and Rebecca has confirmed that. That's the position we have. The noise mitigation measures we are putting in, which are all the specifications are in the case summary, together with the ops manual, are measures which will promote the licensing objectives. And we'd be happy that it's a condition of the licence that the operational manual has to be sent to Environmental Health and Licensing and the police, and we'll share that with everybody, and obviously we'll talk to the responsible authorities about that. But that's the position that you have in making this application. That there are, of course, side issues. We all agree it's strange that people want to smoke. But if you're in that club on Saturday night, Jerry will say there were lots of people who wanted to smoke. We are adamant on the customers leaving drinks, and they like to hold drinks when they have a cigarette. Again, this is all customer behaviour that we can't dictate. Councillor Gordon may or may not know that from his own experience. Customers like to hold drinks, and we don't want them leaving the drinks on inside a nightclub where they can't see what's happening to it. We would like everybody who wants to smoke to be able to go and smoke, and we would like to use that area as an enhancement to the premises with the addition of the bar. That's a third point of the application, and I'm always a bit reluctant to say things like this, but I'd rather be straight. There are 3 points to what we want to do to that outside area. We would like you to decide, and we hope you decide on the evidence that you think all 3 can be approved. But if you think one of those 3 points shouldn't be approved, but you may be happy with the other 2 or whatever combination it is, I don't want to go down much lower than that, then please don't refuse that bid in its entirety because you think one might be a problem. Of course, and this is my final word, under the Licensing Act 2003 and the Section 182 guidance, you determine this based on evidence, but you can be absolutely assured that if there is a single complaint about that outside area, and Gavin and his team are made aware of that complaint, then he will be ringing Rebecca and Jerry immediately, and if it is not resolved, we will be back here. And that, with respect to everybody, is, in my submission, how the Licensing Act works. If you don't have evidence against an application as a committee, you can be assured that the procedure for bringing this back to you is a very simple one. It's a review application, and I'm sure you've dealt with on many times over the years, and that, of course, is open to those. So I always think bringing the law in makes it, and taking points on order like this makes it look a bit loyally. We don't want, I'd like to end on, we don't want noise issues. We want our investment to work. We want it to be a very good club in Camberley, and we don't want to be back here. But I'd ask you to take all those other points into mind. Can I just say with regard to the fire officer as well, because I'll look at this whilst you make a determination, and whether everybody feels it can come back to you or not is another matter. We had an email saying Dan, the fire officer, wanted a fire risk assessment and he wanted us to agree to 6 points in terms of things that we do. We emailed back saying all 6 points are agreed and we'll get you the fire risk assessment. I'm certain, but I'll try and dig it out. Dan emailed saying, that's fine, I'll withdraw the representation. Paula is also quite right. We did send a fire risk assessment. We've been open this weekend. And we have a meeting with Dan on Wednesday because he wants to come and talk to us about 1 or 2 points in the fire risk assessment. And we may have to change or amend, we may agree to amend the fire risk assessment. But as I'm sure everybody in this chamber knows, the onus changed from 30, 40 years ago when you had to have a fire officer down saying, tick, everything's okay. The onus is now on the operators to have their own fire risk assessments. And we have one, and so that you know all of the facts, Dan has emailed saying there are 2 or 3 points in there that I'm not sure about. I want to come and have a meeting with you. So we can still be open, but we have to have a meeting with him. And clearly, if he wants things changing and we don't change it, then he'll shut us down. But we will change it. But all of his 6 points were agreed. So Andy's not here today. My understanding was he'd withdrawn, but I'll try and see if I can find that whilst you make a deliberation. But rest assured, if
Can
the fire
you
risk
find
assessment...
that email and send it to Democratic Services,
Yes,
and they
of course
can
I will.
print it off and give
Yeah.
it to us?
Yeah. But rest assured, what if the decision is, and you need to agree everything with the fire officer, of course, there's no way we'd be trading if there was a risk that the fire officer wasn't happy. Thank you.
Right. Paula, have you got anything to add?
No, I'll just dig out the emails of the exchange between Mr. Elias and Dan and bring them down to you when you're deliberating.
Right. Have you all said what you wish to say in support of your case? All right. Okay, right, now, the committee will now leave the room to deliberate, but I would ask that you all remain in the room, as we may need to call you back if there's any point of further clarification which we require. The committee will leave the room with the clerk and legal advisor in order for the decision to be recorded for clarification on legal issues. Has anyone any objections to the legal advisor leaving the committee, well, joining us remotely at our deliberations? You're okay with that? Okay, well, thank you for the time for the moment, and we'll try not to take too long. Can you hear us, Rebecca? Can you hear us, Rebecca? Can you hear us, Rebecca?
Yes, can you hear me?
Okay, thank you for waiting, and we've come to a decision. This is just a short version of the decision, and a published report will be sent out to you within 5 working days with the full thing. So the decision of the subcommittee is to agree the variation of the premises licence, provided that the fire officer's recommendation of all 7 conditions to the fire risk assessment, including a maximum of 750 persons, is maintained at the premises. Each point has been decided on its own merits. Alcohol sales will be allowed on the outside area. Drinks will be allowed to be taken up to the outside area. Capacity is to be increased on a graduated basis, so no more than 45 persons be allowed in the outside area for the first 3 months from the date of the published decision of the licensing subcommittee, and provided no complaints are received by environmental health during that period, the capacity of the outside area will automatically increase to 60. But any complaints, obviously, will be back here. And that's the end of the decision report. So thank you all for coming. Thank you.